Okay, Madam Clerk, you may call the case.
Case number 2008 CF 15606, State of Florida versus Caylee Marie Anthony.
Okay, let the record reflect that the defendant is present along with counsel for the defendant, Assistant State Attorney. Both sides ready to proceed.
Yes, sir.
I believe so, Your Honor.
Mr. Mason, before we proceed to sentencing, Mr. Baez, you had asked me to reserve ruling on your motion for mistrial.
Withdraw that, Your Honor.
Okay. Okay, that takes care of that. The defendant, Caylee Anthony, is before the court for sentencing on counts 4, 5, and 6, providing false information to a law enforcement officer. Mr. Baez, do you know of any legal cause why we should not proceed to sentencing at this time, sir?
It's 4, 5, 6, and 7. Your Honor.
And 7.
And the only legal cause that we have would be the previously filed motions attacking none other. No legal cause why you can't proceed to sentencing with the subsequent remedies if she takes them.
Would the state care at this time to present any matters relative to aggravation?
Not on that issue, Your Honor, no.
State care to present any issues at this time concerning any other matter?
Your Honor. Yesterday, I filed a motion to tax special costs of investigation and prosecution and to reserve jurisdiction. The only reason that I would bring this up prior to the actual sentencing has to do with the jurisdiction of the court once sentence is imposed. If defense counsel intends to appeal the misdemeanor convictions, then this court would not be able to entertain a later hearing until that matter is resolved as it relates to costs of investigation. If, in fact, that is their intent, what we would ask is that the court bifurcate the sentencing hearing, proceeding to the matters of punishment. First, the issue of costs of investigation is not intended to be punitive, and I believe can be handled at a later point in time in a bifurcated type of proceeding that would not divest the court of immediate jurisdiction to handle this matter so that this can be closed as expeditiously as possible. That is the only thing I wanted to bring up at this time.
Mr. Baez?
Mr. Mason, Your Honor, will be handling.
Mr. Mason?
I do not object to the bifurcation process, Your Honor. They have not presented invoices to us or any accounting as of yet, which we will be reviewing and then challenging as appropriate. So she asked for 60 days, and I have no problem with that.
Okay, the court will retain jurisdiction to deal with the issue of cost of prosecution and other costs, I guess, pursuant to Chapter 938. That's the statute that you're seeking those costs under?
It is, Your Honor. Thank you.
Okay. Mr. Mason, mitigation. You may proceed, sir. Okay.
We have, however, the argument, the legal argument, for a double jeopardy.
Go ahead. All right.
May it please the court?
Good morning.
Good morning, Your Honor. Your Honor, before sentencing, we respectfully request that the court address the violation of double jeopardy at issue with respect to counts 5, 6, and 7. Because all 4 statements in the indictment arose during the July 16th interview between Detective Melich and Miss Anthony, All 4 counts of providing false information to a law enforcement officer were one continuous criminal act with a single intent. As such, each false statement separately charged violates double jeopardy and must be reduced to one conviction based on one occurrence and course of conduct. In Hamill v. State, which we provided to the court, that's 934 Southern 2nd, 634, that's a Florida 2nd DCA case from 2006. The defendant was convicted of 15 counts of using a computer to seduce a child. At issue was whether counts 5 and 6, among other things, arose from a single criminal episode. In Hamill, the court articulated the test to determine whether offenses arise from a single criminal episode. In that test, the court articulated that...
Fryer, let me stop you for a second.
Yes, Your Honor.
I don't seem to have benefit of what you said you provided the court.
I apologize, Your Honor. I gave that to the clerk, and I should have instructed that you needed to have that.
Okay. Okay, go ahead.
Okay, thank you, Your Honor. This test requires a court to look to whether there was a separation of time, place, or circumstances between the crimes because those factors are objective criteria utilized to determine whether there are distinct and independent criminal acts or whether there is one continuous criminal act with a single criminal intent. The court went on to say that the spatial and temporal aspects of the crimes, looking at that criteria, a court can ascertain whether the defendant had time to pause, reflect, and form a new criminal intent between the occurrences. Your Honor, in finding that counts 5 and 6 in the Hamill case were a violation of double jeopardy, the court pointed to the fact that there was no temporal break in the conversation or a change in circumstances to warrant separate charges, where the conversation in question spanned several hours. Similarly, Your Honor, the false statements Ms. Anthony made to Detective Yuri Melich occurred during the course of a single interview on July 16, 2008. The interview was one continuous conversation, and similarly, there were no temporal breaks or other objective criteria that would suggest that the defendant had time to pause, reflect, and form a new criminal intent as required so as to not run afoul of double jeopardy. We've also provided the court with 2 other cases. That Hoogd case, that is 511 Southern 2nd 401, and that was out of the 5th DCA. That's a 1987 case, and we also provided the court with Burke v. State. That's 475 Southern 2nd 252, and that's a 1985 case. It's our assertion that the Hamill case is similar in that it touches on the temporal aspects that are present in this case as well. However, the Hoogd decision, the double jeopardy was invoked when the defendant was convicted of 5 incidences of leaving one scene because there were 5 people in particular who were left at the scene of an accident. Burke, on the other hand, is a case that's invoked a double jeopardy where there were 3 convictions of the defendant based on one transaction of 3 altered bills. And those convictions were charged separately. However, because they were found to be one act, double jeopardy was violated in those cases as well. Your Honor, in order to avoid a legal sentence, we respectfully request that the court sentence Ms. Anthony only for one occurrence, one count of providing false information to a law enforcement officer. Further, we reassert that there is an issue of materiality in these charges and should be read into the statute as legislative intent. Thank you very much.
Just a second.
Yes, sir.
Let's look at count 4
Yes, Your Honor.
of providing false information to a law enforcement officer.
Yes, sir.
Specifically, what is alleged in count 4?
Count 4 alleges specifically that on the 16th day of July 2008, that in violation of the statute 837.055, there was a knowing and willful violation in giving false information to Yuri Melich, a law enforcement officer. So that specific allegation was that Caylee Marie Anthony suggested that she was employed at Universal Studios. However, it arose during the July 16th, 2008 interview, as did every other charge, Your Honor.
As a result of her telling the police that she was employed at Universal Studios, did the police have to take any resulting action with their investigation?
They certainly did, Your Honor. However, if we're to charge her, we have to charge her for the crime. And the crime here arose out of all 4 incidences were a part of the same continuous act, even though there were several false statements.
Okay. Count 5 alleges she violated that statute by doing what?
That during that same interview on the 16th of July, that Miss Anthony identified a person as Zenaida Fernandez Gonzalez and suggested to Detective Melledge that she left her child with this woman.
And did that require a separate and distinct act on behalf of law enforcement to investigate?
It did, Your Honor. However, I would assert that the reaction based on the violation isn't how we measure this. How we measure if there was one instance, one particular criminal act that wasn't broken up temporally, we look not at the resulting conduct of the police department. What we look at is the conduct of Miss Anthony and the temporal aspects of her statements as required under this Hamel decision.
And count 6,
Yes, Your Honor.
what was she alleged to have done in count 6?
During the same interview on the 16th with Detective Melledge on that 16th day of July in 2008, the allegation and the conviction is based on Miss Anthony informing Detective Melledge that she identified a Jeffrey Michael Hopkins and a Juliette Lewis, that she had told them of a disappearance of her child. However, we reassert that there's a materiality issue related to this particular charge, and again assert that this is out of the same instance of conduct.
And count 7.
Count 7, Your Honor, this is the same interview that we've been discussing to Detective Melledge, and this allegation is based on Miss Anthony asserting that she received a phone call from Caylee Marie Anthony.
Just a second, since you just provided these cases
Yes, sir.
to me. Let me read them right quick to see if I have any additional questions
Yes, sir.
before I hear from the state of Florida. One last question, Ms. Fryer.
Yes, Your Honor.
Are you saying that Ms. Anthony did not have time to pause, reflect, and form a new criminal intent for each one of those 4 separate acts?
Yes, Your Honor. As the test is articulated under the Hamel decision, there has to be some separation of time, place, or circumstances. In the situation that we're dealing with today, there was one single interview. It can't be said that there was a break in either time, place, or circumstance as required to not invoke double jeopardy.
Thank you, Ms. Fryer.
Thank you, Your Honor.
Response from the state of Florida.
Like the court, I was only provided with this motion this morning. However, I believe even under their case law, as well as case law from the Florida Supreme Court, specifically Valdez, which I did not bring copies of, unfortunately, found at 3 Southern 3rd, 1067, a Florida Supreme Court case from 2009.
3 Southern 3rd.
Second, I'm sorry, 3 Southern 3rd, correct. 1067, Florida Supreme Court 2009, and Anderson at 697 Southern 2nd 309, the Florida Supreme Court case from 1997. These are not single acts. This is different core conduct. It is our position that there is a temporal break between each of the lies, and there are several, not just the ones charged. but that these lies occurred over the course of 3 separate statements. The fact that they all occurred on July 16th of 2008 should be of no consequence. The court, through the course of pretrial hearings as well as the trial, knows that Ms. Anthony gave statements at approximately 1 a.m., 4 a.m., and then 1 p.m. on July 16th of 2008. Each of the lies are material to the issues that were investigated by the sheriff's office as a result of the lies. Each were intended to mislead law enforcement and to send them, as Ms. Anthony herself at the end of the final statement indicated, on a wild goose chase. They are not degree variants of the same crime and are not a single criminal act. Most of the time when we're not dealing with multiple punishments for a single act, what we are dealing with are whether or not a single act can be broken up into episodes. We typically see this in sexual battery cases where there are multiple sex acts performed on a single victim at the same time. And then the issue is whether or not there is a break between the various types of penetrations in those cases sufficient to convict for separate acts. And indeed, the case law suggests that there is a sufficient break where an individual does have the time to pause and reflect, as the court has already inquired. Given the fact that there were multiple statements over the course of 12 hours, it is the position of the state of Florida that these separate acts, as separately alleged, do not violate double jeopardy.
That Valdez site was 3/7/3 edition, what page?
1067, if I have that right.
1067?
1067. I do have a copy. This is a situation where an individual was charged with 2 different counts for 1 act of shooting. Would the court like my copy?
If it's just a second. Okay. Mr. Mason, Mr. Baez, anything else you would like to say prior to the court imposing sentence?
No, sir.
Does your client wish to say anything prior to the court imposing sentence?
No, Your Honor.
The court will make the following finding concerning the defense motion to bar imposition of sentence on these 4 distinct counts as violating double jeopardy. Count 4 of the indictment alleging providing false information to a law enforcement officer basically dealt with the following conduct. It is alleged that the defendant was employed at Universal Studios during the year 2008. This information was given pursuant to an investigation for a missing persons report. That information caused law enforcement, in following up on that statement, to go to Universal Studios to expend law enforcement resources to determine that, in fact, Ms. Anthony did not, in fact, work at Universal Studios. Count 5, Ms. Anthony informed the authorities that she had left her child, Caylee Marie Anthony, at the Sawgrass Apartments with a babysitter. which calls law enforcement again as a result of a missing persons report to develop and follow various leads trying to locate this babysitter, commonly known as Zanny. Count 6, again, dealt with the fact that she had informed two, quote, employees of Universal Studios, Jeff Hopkins and Juliette Lewis, of the disappearance of Caylee Marie Anthony. This Anthony in count 7 indicated to law enforcement that she had received a call and spoke to Caylee Marie Anthony on July 15, 2008 at approximately 12 p.m., thus causing law enforcement to devote extensive resources. As a result of those 4 separate and distinct lies, law enforcement expended a great deal of time, energy, and manpower looking for young Caylee Marie Anthony. This search for her went on from July through December, over several months, trying to find Caylee Marie Anthony. 4 distinct, separate lies. Just as the jury spoke loud and clear on counts 1, 2, and 3 by their verdict, they also spoke loud and clear as to the remaining counts 4, 5, 6, and 7. There being no legal cause shown why this court should not impose sentence, and the court having previously adjudged you to be guilty of the crimes contained in counts 4, 5, 6, and 7, I will sentence you to 1 year in the Orange County Jail, imposing a $1,000 fine on each count, all 4 counts to run consecutive to each other, giving you credit for the time that you have previously served. Mr. Baez, Mr. Mason, we're going to spend some time this morning figuring out her credit for time served. And it's going to take us probably about an hour to sort it out because of the previous sentences that she has been given. But with the good time and gain time, depending on preliminary figures, sometime early August, maybe late July. But I can't say that until after I first determine time served, and then the jail has to apply, according to their figures, their good time and gain time that she has gained in this. So if you want to wait around, or we can communicate that with you, and if you have a different figure, then we can get that taken care of. I will reserve jurisdiction for 60 days to determine the cost of prosecution and investigation. Tell me when you'll be ready.
I've been advised a minimum of 30, so any time after that would be acceptable.
Well, Mr. Mason?
I'm going to want to have some time whenever they get around to providing and gathering up their invoices so we can check the validity of those and potentially conduct some discovery on it. So at least 30 days, I would assume. Depends on when she gets it to me. If it gets it to me on the 29th day, that's not going to be good.
I would do that to Mr. Mason. They have indicated that they believe they can have all the documentation to me within the time frame that I've suggested, and then that should give Mr. Mason ample time to review the validity of the affidavits of the sheriff's office.
Well,
Anytime I'll ask for it after she gets it to me.
well, I'm trying to give you a date now. The week of August 15th, I will not be around. The week of the 22nd, I'm involved in an evidentiary hearing on a 3851 case that's supposed to last 3 days. I have some time on the 25th and the 26th. Depending on how long you need, I can fit you in on the week of the 29th, but I would have to fit you in because I'm unfortunately going to have to take over Judge Adams' division since he's leaving at the end of the month. I have again the week of August 1st, but I have to fit you into that division's regular work. The week of August 9th with the same proviso, except that Friday. So when would you like the hearing, folks?
Any of those options is acceptable to Your Honor.
You can have the 25th or the 26th. That should give you more than enough time to get the information, get it to Mr. Mason, Mr. Baez, and have them digest the information. So you want to do it Thursday or Friday, the 25th or the 26th, Friday being the 26th.
Thursday's fine, 25th, that's acceptable to council. And I don't know what Ms. Anthony's status will be at that point. Do they want to waive her appearance at that or have her present? I don't know if you want to address that issue now.
The 25th, according to the preliminary calculations, without going over, double checking some things, she won't be there.
So that's why I didn't know if we wanted to address whether or not the court would require her attendance. It's not a punishment aspect to the sentence.
That's
so
entirely left up to her and her counsel. As far as I'm concerned, she can waive her appearance or she can come. That's left up.
It'd be our intention to waive her appearance of those proceedings, Your Honor.
Okay. I will also impose the statutory court costs. Ms. Anthony, you have a right to appeal the judgment and sentence. that I rendered here in your case today, provided you file a notice of appeal within 30 days of the day's date with the clerk of the court. If you cannot afford the services of an attorney to assist you with this appeal, the court will appoint one to represent you. Bearing those rights in mind and after consulting with your attorney, do you wish to appeal?
I can have a moment, Your Honor.
You may.
Your Honor, we can't, we would like to reserve our right to make that decision at a later time.
You have 30 days from the day's date to file a notice of appeal, or you forfeit or give up your right to appeal. Does she have the financial wherewithal, Mr. Baez, if she decides to appeal, to pay for appellate counsel?
No, Your Honor, but we would,
If she decides to do that, then please make sure that she fills out an affidavit of insolvency with the clerk of the court to timely bring that matter so counsel can be appointed.
yes, sir.
As you know, if she does not file a timely notice of appeal, then she forfeits or gives up her right to appeal. If she decides to appeal and she wants appointed counsel, but it will be your responsibility to file the necessary appellate paperwork, that is the notice of appeal, statement of judicial acts to be reviewed, and designation to the court reporter. It will be your responsibility before you are relieved of your responsibilities as far as this case to have those documents filed. Are there any other matters on behalf of the state of Florida?
Nothing from the state, Your Honor. Thank you.
Are there any other matters on behalf of the defense? Okay. Court will be in recess.